Good morning, Counsel.
Good morning, Your Honor. May it please the Court, my name is Elaine Perinsky, and I represent the defendant, the appellant in this case, Mr. Ramon Perez. Mr. Ramon Perez did not get a fair trial from almost the beginning of this trial until the end of the trial. It started with jury selection and jury voir dire. As Your Honors know from the brief, the Commonwealth requested that the judge give an individual voir dire question on the CSI effect, even though the judge did not believe that it existed. Defense counsel did not object, but I think it became very clear early on to both defense counsel and the judge that this was an unfair process. As we know, we asked the voir dire questions to ferret out any extraneous influences that might happen during the trial. We want the jurors to solely look at the evidence in the case.
Did the defendant eventually express satisfaction with the jury?
Ultimately, he said he was satisfied.
Did he run out of peremptory challenges?
He did not run out of peremptory challenges. 26 jurors were removed for cause because of this CSI question. Some of these people, they said they didn't even watch the program. So the defense counsel, I would suggest, was an agreeable person who became very frustrated and at one point said to the judge, "Would it matter what I say?" Something to that effect. He tried to propose a remedy that the judge also asked the jurors the questions, the Bowden question, and the judge rejected that remedy. So I would suggest to the court that it started out of balance, and a trial is supposed to be about balance, and so that at the end of the day, neither party feels as though it's received a raw deal. And I think that this case started out of balance, and I would encourage the court to look at this, just an example on page 23 of the brief of a typical question. All right, let me go back to the scientific evidence. Do you ever watch CSI? No, I don't watch them, no, not a lot. Maybe the old Law and Orders. What role do you see scientific evidence playing in the case? It's almost like a quiz. They could prove his fingerprints were on the gun, or they had evidence like that, or they could prove he was DNA evidence or something like that. I would think that would be, all right, give them more proof, the juror says. Ask you, if they had no DNA, no fingerprints, and no other scientific evidence that tied that accused to the crime, would you conclude that you must automatically find that defendant not guilty? I would say so unless they had a witness. All right, and then the jurors, totally confused, or more than one witness that could put him right there, and right there with the person that day at the time. Okay, and then the juror says, or other evidence. Could you be a fair and impartial juror in this case? Yes. Will you step back just for a minute? And then the court says, I think this is exactly the profile that Mr. Shea, the prosecutor, has been concerned about. The contention is that she cannot be fair and impartial. This juror was just trying to answer what to me seemed like more of a quiz than trying to ferret out a biased juror. This juror was clear she could be impartial. And the judge came to his own conclusion, and I would suggest that is on page 26, that this was an unfair process, and he would never do it again. He stated, although we've had a number of initially affirmative responses, some of those jurors have backed off upon questioning. To ask the proper follow-up question, one would almost have to give them all the evidence in the case. which was happening in this case. If you had this evidence, would you find the defendant guilty? And of course, that's not what we should be asking jurors. So he decided he would never do this again. Unfortunately, there was a defendant sitting in front of him on trial for life. He couldn't wait for the next trial. His trial was now. So this is a judge who made this determination. He didn't use the word unfair, but clearly that is what he was suggesting in those comments. So I would suggest to the court that we cannot be sure that Mr. Ramon Perez had an
Well, if the judge had thought that the process was unfair to that point, couldn't he have simply dismissed the venire and started again? Or defense counsel could have made a motion for such?
Yes, that is what should have happened.
Okay, no, there was no motion by defense counsel.
The only motion by defense counsel was to ask a balancing question. He was trying to achieve balance.
And the judge, even though he recognized for whatever reason, he didn't say why he wouldn't do it again, but he said he wouldn't do it again. But if he had thought that it was unfair, there was appropriate action he could have taken.
Which he didn't take. He should have taken that, yes. I would say...
Well, he's an experienced trial judge, so it would have been in his mind as a possibility if he thought it were unfair.
Well, I think from his comments about what I just read, what he stated, this isn't what we should be asking jurors. He knew. This was like an experiment for him. He was not in total belief that the CSI effect existed. So this was an experiment for him to try this out. And you'll see in the transcript, he talked about some other judges do it, some don't do it. For him, this was an experiment. Unfortunately for the defendant, this was a trial for his life. So I think midway through this, he decided this is not a good thing. We should not be asking jurors these questions, and I will never do it again. Unfortunately, as I stated, the defendant's trial was that day. So I don't think the experiment worked out for him, and I'm sure he never asked that question again. So I will just briefly touch on the Bowden issue because I know that a court is not required to give a Bowden instruction. But as I stated, the trial is about balance, and there's got to be some way to bring it back into balance. And this, I think in this particular case, it was an abuse of discretion not to give that instruction. Excuse me. Based on the fact that the judge didn't believe in the CSI effect, yet asked the questions, didn't believe in the Bowden, and then refused to give the instruction. That's all I'll speak about the Bowden. The trial was unfair in another respect. And I think the Commonwealth concedes this, that no lay witness or expert witness should give an opinion about the defendant's guilt. And that happened in this case. Commonwealth tries to suggest that it was the defendant's fault, defense counsel's fault, that he sort of wanted this type of information elicited from the defendant. But I would suggest that that reasoning is faulty for a couple of reasons. One is that, and again, the defense counsel did not object or ask that this be stricken from the record when the witness said, "I thought and I think that Ramon killed Henry," an impermissible testimony. But he did object 2 questions later when it was asked again, well, what happened? What do you think happened? At that time, the judge overruled the objection. Not only did the judge overrule the objection, I think he made the whole situation worse by asking, after the witness testified, "I think and I thought Ramon killed Henry," the judge said, "Did you think he did it that night?" And there was a whole good 20 lines on this person's belief that Ramon killed Henry. So I would suggest to the court well, it's fairly basic that laypersons cannot, or expert people cannot give an opinion regarding the guilt of the defendant. And the defense was that, one, inadequate investigation, and I think I cited a number of inadequacies, things that did not happen, and also that the main witnesses against the defendant were his girlfriend, his wife. He had off and on again relationships with these people. They were sometimes volatile. So the suggestion that the defendant wanted the witness to say, I think that Ramon killed Henry, I would suggest is ludicrous. And it did have it, because there was no objection. The question is whether it substantially affected the rights of this individual, and I would suggest that it did. The case against this individual was not strong. Again, it was the girlfriends who testified against him, this one girlfriend in particular. So the jury would give great weight to her testimony because she was the girlfriend of this defendant at the time. Just in case the judges do not know, at the time it was also another gentleman who suggested that she go to the police and tell them these things, and it wasn't too long after that she ended up with this gentleman. So that, again, there was evidence contrary to the defendant's guilt. Next, I would like to talk about the prior bad act evidence, mainly about the testimony given from the defendant's ex-wife, although she was actually still considered married to him at the time, about her son stating, their son stating, 5-year-old son stating, she was asking him whether he wanted to go with daddy, and he, according to her, he said, no, I hate him. If I have to go with him, I'll kill myself. I would suggest to the court that this is prior bad act evidence, a suggestion of prior bad act evidence that the Commonwealth presented solely because they wanted to put this person in a very, very bad light.
What was the relevance of that statement?
I'm sorry. There was, I would suggest there was no relevance to that statement. I think the Commonwealth will say that it will show the defendant's state of mind on the night of the murder, the alleged murder.
State of mind as to what?
That he was so angry that he would go out and kill an ex-coworker, a friend, someone with whom he dealt drugs with, someone who was actually his supplier of apparently he was his supplier of marijuana. So the Commonwealth would suggest that because of this phone call with the wife, talking about a child visitation and child support, that he was so angry that he went out and killed this gentleman, because there was no other there is no motive. There was no motive.
Wasn't the connection to the fact that he took marijuana and then had money and then paid support? I mean, it wasn't just he was angry. He was feeling the pressure about providing support. Wasn't that the connection to this conversation? Pressured by her to get support and being upset about the circumstances?
I think the connection to the particular statement that if I have to go with him, a 5-year-old saying, if I have to go with him, I'll kill myself. Their justification for that particular statement is that it just made him so angry. As far as the child support, There was some discussion, but not much discussion. And I would suggest they point to no other evidence to say that this guy was so angry that he would go out and shoot somebody for no reason.
But you say there was no motive, no reason. What about a reason of robbery? People shoot people every day because of robberies. He stole he stole a lot of marijuana, the bricks of marijuana.
Well, that's the suggestion,
Well,
if you
there's
believe the
evidence of
wife.
motive.
The question is, this gentleman knew the victim. He had worked with him. There was some evidence that he had dealt drugs with him before. He was his friend. There was no suggestion that, he was his supplier of drugs. So to disrupt that, in a way, he would be cutting off his own business. So,
I imagine one can find another supplier of drugs.
well, if the suggestion is him giving the wife $100, if that is an amount of money that is considered, substantial, I would suggest that it isn't. The trouble is that this trial was infected throughout with hearsay, highly prejudicial evidence that had nothing to do with that particular motive, whether it was robbery or not. A 5-year-old child whom nobody saw, nobody heard anything about other than these horrible statements, became a big part of this trial. I would ask the court, and this is in the other issue of admitting the journal of Ms. Doobie. In that journal that they admitted, there's 2 pages of highly prejudicial information, and it's on A22 and 23 in the appendix. And I would ask the court to read that and ask yourselves whether this type of information should be part of a trial. Where is the relevance? And I'll go to that issue now, the issue of whether the journal should have been entered into trial. Ms. Doobie, the defendant's wife, the mother of the 5-year-old, kept a journal. She gave some parts of that journal to the police. She testified. She was cross-examined, redirected. On cross-examined, she testified that the defendant went to her house. They had the earlier argument on the phone where the earlier statement came about. Went to her house around 10:15, and around 10:15, and they just argued further about this whole issue of seeing the children. And I would suggest the main argument was about seeing the children, not support. It was about he wanted to see his children for the weekend. So support was not the main thrust of the argument. And she testified to that on cross-examination. The problem for the Commonwealth was that conflicted with their theory that the defendant made a 911 call approximately at around 10:15, 10:30. So, as I say, she testified to that. The Commonwealth had in their possession her diary, her daily journal. They did not ask her any question about it while she was on the stand, did not try to impeach her with her journal while she was on the stand, and I would suggest that Commonwealth acknowledged, rightly so, that that conflicts with Chapter 233, Section 33, as far as impeaching your own witness, that they didn't do it while she was on the stand. They waited, and they put it in through an officer, her journal. The defendant objected, and I would suggest to you that it was highly prejudicial to allow that to go in at the time when the witness was there available. They had ample opportunity to question her regarding that journal. And nobody knows if it was altered in any way. It was never shown to her again.
I'm going to have to interrupt you. Your time is up.
Oh, I'm sorry.
Thank you.
Thank you very much.
Good morning. May it please the court. David O'Sullivan for the Commonwealth. I have with me Assistant District Attorney Gerald Shea, the trial prosecutor in this case. As to the first issue, the court has to decide whether first the question propounded by the judge at the prosecutor's request regarding whether the jurors would require scientific evidence as a requirement of meeting its burden of proof, as a requirement of finding that the Commonwealth had met its burden of proof, and whether the judge's excusal based on the jurors' answers to that question, his affirmative answers to that question, impaired his right to a fair trial. The question is unpreserved. The defendant highlights at one point in the trial, it's addressed at footnote 41 of the Commonwealth's brief, one instance in which defense counsel stated or asked whether it would do any good, quote unquote, do any good for him to object to excusal of a juror on another basis entirely, hardship. That question cannot be interpreted reasonably as dissatisfaction with either the scientific evidence question or the excusal of jurors on that basis. It's a completely different ground.
What do you think about this question? The judge obviously was very dissatisfied when he got into it, saying, I don't think this is a great idea. We're obviously going to have to say something about whether judges should ask such questions. What's your view?
The question was perfectly proper. It was motivated by good faith concerns on the part of the prosecutor, which the judge recognized, which stem from, first of all, the prevalence.
Commonwealth had no forensic evidence.
Commonwealth had no forensic evidence in this case.
So why is that a big deal?
Because jurors may cull from popular media or from their perceptions about the advancement of science in general that the Commonwealth, as a requirement of meeting its burden of proof, must introduce this type of evidence.
So should we have judges ask questions about, would you convict solely on the basis of eyewitness testimony? I mean, should we start getting questions of jurors as to what kind of evidence they would likely convict on or not convict on? Isn't this going really, does this really help? There's a lot of stuff around about eyewitness testimony not being very reliable. So should the judge start now inquiring whether they would convict if it was eyewitness testimony alone, if that's all the Commonwealth was presenting?
Well, it's here there was certainly a basis for the judge or for the prosecutor to be concerned about the possible effect of these shows, given his experience in given his colleague's experience in a case in which 14 jurors raised their hand yes to this question. So whether they should ask, whether a juror could convict on based on eyewitness testimony, I think there wouldn't be as much of a basis for that type of question as there would here. Certainly, this.
So, all right, so you have a case in which all the Commonwealth's evidence is going to be circumstantial. The Commonwealth wants jurors to be asked, would you convict if the only evidence was circumstantial? Or would you not? What kinds of questions should we be asking?
Well, the question is the propriety of this one and whether a judge would be in his discretion in asking, well, look, potential jurors, this is a circumstantial evidence case. Would that prevent you, the absence of direct testimony, would that prevent you from considering a guilty verdict?
So you think that's an appropriate question to ask?
I wouldn't say that there's as much of a need for that type of question because, for example, in the preliminary instruction, the judge said this will be a circumstantial evidence case. So implied in that is the fact that you can convict on circumstantial evidence. It's one thing for this court in saying to note correctly the absence of empirical studies that conclusively prove the existence of a CSI effect. It's another thing entirely to say it's an abuse of a judge's discretion to inquire about its existence as to an individual juror. And with respect to their answers, the proof is in the pudding. When these jurors answered yes, the judge was certainly within his discretion in taking them at their word that they would not convict. Automatically, they would acquit if the Commonwealth failed to produce scientific evidence of guilt. Of course, any juror that labors under that misimpression is an unfair juror to the Commonwealth, and of course this court and the Supreme Court have recognized the public's interest in affording the prosecutor one fair opportunity to convict one fair opportunity to present its evidence to an impartial jury, and that would be frustrated by the presence of even one of these jurors. So, it is, I cannot say that it would have been outside the judge's broad discretion to decline to ask this question. But on the other hand, the answers to these questions reveal what a sound exercise of discretion it was, because the presence of any one of these would have led to, in our view, what would be an unjust acquittal. Now, with respect to the judge's statements after the fact, on the third day, in fact, of impanelment, in which he said, I probably won't ask this again. The judge in no way suggested that the process before that point had been unfair, as is implicit in his failure to then dismiss the panel. Again, this is an experienced trial judge who, of course, if he saw any unfairness in this proceeding to the defendant, he would have dismissed, and as is also implicit in the failure to even move for a dismissal of the panel by the defendant. What the judge was referring to was some jurors' apparent inability to understand the question and the need to ask more and more follow-up questions. Well, CSI, the types of evidence that are introduced in those cases, would you require that type of evidence in this case? And again, an important point is that the question pertained to a type of evidence, not the quality of evidence. The defense tries to conflate the two. All the question pertained to was whether they would require scientific evidence as a condition of the Commonwealth meeting its burden of proof. It didn't denigrate or trivialize the Commonwealth's burden of proof by suggesting, for example, and as the instruction in Seng came close to suggesting, that there's one standard that applies on TV and one standard that applies here. It didn't do that. It merely asked whether they could accept the truism that the Commonwealth need not present scientific evidence as a condition, as a sine qua non for meeting its burden of proof. Now, with respect to the effect of this, the alleged effect of this on the defendant's Bowdoin defense, it had no effect. This court has never said, of course, that a Bowdoin instruction is required. What needs to happen is that the judge is not permitted to take that defense away, nor is the prosecutor permitted to take that defense away from a defendant. That was not done here. They did not ask, for example, would you be able to convict only on the evidence that's presented to you and not consider any omissions in the police investigation? That was not what was asked. Briefly, with respect to the opinion testimony, the opinion was elicited at the opinion of the defendant's guilt from his girlfriend, Michelle Chisholm, was elicited at the defendant's insistence. When the prosecutor on redirect examination of Chisholm sought to explore the nature of the agreement, not the prosecutor, the defendant objected and said, I would like you to elicit the elements of the offense for which he believed she was subject to prosecution, that being accessory after the fact. The prosecutor did so. He asked, and the judge followed up with questions eliciting, well, what did you believe you were in trouble for, and it was accessory after the fact. Well, what did you believe you were an accessory to? And she stated, without objection, I believed and believe that the defendant committed the murder. There was no objection to this. The defendant later exploited it in cross-examination and in closing by pointing out the fact, as an attack on Chisholm's credibility, that she did not flee the defendant. She left her child in his care, despite her alleged belief that that he was a murderer. Her alleged belief that he was a murderer, and this was part of a larger attack on her credibility. The prosecution largely depended on her testimony, and the defense theory was that she fabricated it in conjunction with another man, Martin Irvin, in order that she may start a new life with him. With respect to the prior bad act testimony, the relevance of the statement of hatred of the defendant's son to him is twofold. First of all, it shows his state of mind of anger and hostility.
It shows the defendant's state of mind of anger and hostility towards
Yes.
whom?
Towards the situation,
Towards the situation?
the situation with his wife and
And what's that got to do
ex-wife
with the
and son.
defendant? And what's that got to do with the victim?
Well, it shows that the murder was motivated by a desire to rob the victim, and the robbery was motivated in turn by a desire to repair his apparently broken relationship with his ex-wife and his child by getting current on his child support payments, which he in fact did the day after the murder. First payment in a couple months he made was on the day after he shot the victim.
So the fact that his son hates him is relevant to his state of mind and his motive, which would be to rob and kill the victim to get money to pay child care.
Yes.
Is that that's the way it was argued at trial, so it was
Yes.
presented?
Yes.
All right, how much was the child care?
How much was?
How much did he owe?
$100 a month is what he was paying.
And he was in arrears, though, wasn't he?
He was 1 month. He had not paid in November or December, and it was mid-December at that point. And this had been part of their conversation, on the day of, I believe, on the December 13th conversation with Doobie included the fact that he had not paid child support. So with respect to the authentication of the journal and its relevance and the propriety of permitting the prosecutor to impeach Chisholm's testimony by introducing through a trooper the fact that her journal, which she had given to the trooper in the course of the investigation, didn't record a meeting that she said she had with the defendant on the night of the murder.
And I don't understand why she wasn't confronted with that.
Well,
She might have had an explanation, you know? I mean, I just don't understand why that wasn't the appropriate way to deal with this.
well, that was one way to deal with it. This is another appropriate way. And what the questions are.
She was never asked. I don't know. I haven't read the transcript. Was she asked? Did you note this in your journal?
She was not asked that. She was not asked whether she noted it in her journal, but the questions that the judge looked at was, well, can we authenticate this through the trooper? And his answer was yes, because the witness Doobie testified that she in fact kept a journal, that she recorded her daily interactions with the defendant in it. The judge confirmed that by looking at pages of the journal, which in fact included some rather mundane interactions with the defendant on a daily sort of log basis. And, the judge inferred from that, or he determined that as a permissible inference, that she would have recorded this meeting. And, if I could back up what we're talking about is Doobie's testimony, which is brand new, that she had not only spoken to the defendant on the night of the 13th, but she had also met him later that night. She testified at trial that she was still in love with the defendant, and it was the Commonwealth's theory that this testimony was fabricated in an effort to provide him an alibi.
So Attorney Perinsky says, if I understand her argument correctly, that you would not have been able to authenticate the journal through Doobie, because that essentially would have been an act of cross-examining or in trying to impeach your own witness. So why should you be able to do it through the back door?
Well, we, as I understand the defense argument, it is that we were required to confront her with the journal and authenticate it through her and allow her to explain its...
Which she says you could not have done.
My understanding is that she says we could have done it and should have done it. She could have confronted Doobie with the absence of an entry in her journal reflecting that meeting, and should
Couldn't
have.
defense have asked permission to recall Doobie?
Absolutely. Yes, she could have, and he could have and did not. It was perfectly permissible for the prosecutor to elicit from the trooper to whom this journal was given in the course of the investigation, and which the trooper had reviewed, the fact that there was no entry reflecting any such meeting, even though it was a detailed entry about the phone conversation.
Why was the
earlier that
journal
night.
admissible to begin with?
The
It's
journal
an
was,
out-of-court statement by a witness.
it was offered not for its truth, but on the issue of Doobie's credibility. So,
Now, well, how, you're saying that who called Doobie to begin with?
Doobie was a Commonwealth witness.
Okay, so, and she was impeached, so this was a prior consistent statement, in other words?
No, it was what Doobie's testimony was impeached with in the trooper's testimony was the absence of an entry reflecting her testimony. She testified that she kept a journal in which she recorded these daily
and this
events.
statement wasn't in the journal, a statement about meeting him that night.
Right. That is not a prior inconsistent statement. It's a failure to record that any such meeting where there's a foundation to believe that she would record such a meeting. That is different and takes it outside the ken of a prior inconsistent statement, which the Commonwealth admittedly would have to confront her with it and give her an opportunity to provide an explanation. Not so here, where all you're offering is her failure to record that in something she had given police that purports to be a recordation of her daily interactions with the defendant. And it was offered again, not for the hearsay purpose of its truth, for the truth of the matters that were in there, but for the purpose of impeaching Doobie's credibility. No limiting instruction was requested by the defense, and nor was one given.
Well, who offered the journal?
The journal was offered by the Commonwealth.
That's what I thought. So how was the Commonwealth offering evidence to impeach its own witness?
It's permissible to impeach your own witness under the statute, which is not relied on by the defense, but under the statute, which is cited in the Commonwealth's brief in a footnote, and I don't have the site memorized, but what's required is where the Commonwealth impeaches its own witness with a prior inconsistent statement, it must give that witness an opportunity to
explain.
to present them with a prior
Right.
inconsistent
But you
statement,
didn't
give
do
them an
that.
opportunity
But you didn't
to
do
explain
that.
But what is offered here is not a prior inconsistent statement.
Oh, come on,
Well,
really?
this is,
It's exactly what it's for.
Well, the purpose is that it is not a statement. It's the absence of a recordation of an event, which is not the same thing as saying a prior consistent statement would be, we didn't meet later that night.
so why are you offering that? Because you wanted to show that she was lying at trial?
We wanted to show that she had made up the fact that they had met later in the night. And by the way, it was also cumulative.
So of course you didn't offer it through her, because she might well have come up with a reason why she didn't write it in her diary.
It would have been proper to offer it through her, but we submit it was perfectly proper for them to admit this testimony through the testimony of the trooper as well. And as a sort of a side matter, this evidence impeaching her credibility was cumulative of testimony from the trooper that the prosecutor asked, well, had she told you previously about any such post-phone conversation meeting? No, she had not. So this is the first that the trooper essentially had heard of this testimony about a post-phone conversation meeting.
Can I refresh my recollection? Was this objected to, and if so, on what grounds?
This, the testimony of the journal, yes, was objected to on 2 grounds. Authentication,
Yeah,
i.e. she had to authenticate it, not him.
right.
And the judge overruled that. And the second is foundation. He submitted that there wasn't enough for the judge to conclude that she would have, or for it to be a permissible inference, that she would have recorded such a meeting. Those were the 2 grounds that the judge considered at length in a sidebar.
No other grounds? I mean, this is 2 pages of why the defendant's a bad father.
This
what
is,
it is.
but if I could briefly, the defense elicited testimony from
Okay.
about the defendant's abusive relationship with his ex-girlfriend.
Thank you, counsel.
Thank you.